So I'm going to break the mold in a few different ways here. So first, I'm going to speak without slides. Second, I am a lawyer, but I have no neckwear. And third, I'm going to sort of zoom out a little bit from thinking about technology in particular to thinking about the First Amendment and businesses, really, in a way that will connect both some of the talks in this panel and some of the talks from the previous panel as well. And so my basic proposition is this, and that is that the First Amendment does not, in fact, protect either businesses or doing business. Now, that's a rather extreme claim in some sense. But what I mean by that is that it doesn't protect either businesses or doing business as such. And that instead, sometimes we allow either businesses or people doing business to raise a claim, but we do so in service of some other goals, of a goal of actually protecting individuals who are not engaged in doing business. And that's the reason why we sometimes want to give such a claim either to businesses or people doing business. And so what do I mean by businesses or people doing business is I'm referring both to the corporate speech doctrine and to the commercial speech doctrine. And in both of these cases, we're talking about First Amendment interests that should be regarded as derivative of the interests of others, derivative of the interests often particularly of the listeners of the audience rather than that of the speakers. So in order to sort of think about why that might be, now the idea here is that protecting either businesses or doing business simply isn't compatible or isn't a necessary incident of essentially any of our major theories of the First Amendment, reasons why we sort of have the First Amendment in the first place, reasons why we might want to define coverage in a particular way under the First Amendment. Now, some of these I think some of these claims are relatively straightforward. So, for example, the one that corporations, have no self and therefore can't sort of develop their selves as such. But some of them I think are a little bit less obvious, and so I want to just focus on a couple of these. One is, well, what about non-corporate but commercial actors, right? So in other words, individuals who are engaged in commerce. Because the argument might well be that, well, look, okay, so even if corporations don't develop their selves because they have none, individuals might well want to develop their selves through the mechanism of actually engaging in commercial activities. And as to that, I actually think it's not a terrible idea that they, in fact, are probably doing some form of self-development, engaging in commercial activities. The difficulty becomes that at that level, it's hard to see any form of human activity that doesn't fall within that parameter, right? And so if we're going to not make the First Amendment simply a regulation that disenables the government from reaching any form of human activity, that suggests we have to break some distinction between the kinds of human activities or the kinds of self-development that we mean to cover under the First Amendment and the kinds that we don't. And with respect to that, I would say that that there is a meaningful difference with respect to expressivity or the notion of actually expressing oneself that is in fact distinct with regard to what it means to sort of speak in the usual sense, actually to talk to people, to communicate ideas and the like, and to engage in commerce. And that we should understand what people are doing when they are speaking as commercial actors as being distinct from what they might do when they're just giving a speech, when they're conveying ideas, when they're even just writing in their own diary, when they're engaging with ideas in various ways. Now, I realize, of course, that that's not a sharp line, and I think that is part of the difficulty with defining commercial speech generally, right? Because of the fact that it's not possible to just sort of sharply draw this line. But I do think that it's necessary to draw this line, and that by drawing this line, we then come to understand why it is that insofar as individuals are engaged in doing business, we should understand what they are doing as falling outside of the First Amendment, or at least intrinsically, in terms of their intrinsic interests as such. And the other might be in thinking about the relationship between corporate speech and a kind of marketplace of ideas or truth-seeking function of the First Amendment. Because one might also say, well, look, if we're going to adopt a kind of marketplace perspective and a perspective that says that the point of the First Amendment is to seek truth, why can't we say that corporations have an important, maybe even key role to play in actually developing truth in those ways? And I actually think that could be right too, though I think it can be attacked in various ways as well. I think perhaps tomorrow we'll want to take issue with that, that aspect of the claim. I'm not going to go quite so far as to take issue with that aspect of the claim, but instead just notice still that even if corporations have a role, the role that they're going to play in that is an instrumental one rather than an intrinsic one. That is to say that the goal here of our truth-seeking function is ultimately to be able to develop ideas, but develop ideas with respect to individuals, ideas that individuals hold, ideas that individuals can do something with, that the corporations as such, again, I don't mean to suggest they don't have a role to play, right? But corporations as such are not in that sense the target of a kind of marketplace of ideas or a truth-seeking function. That ultimately those kinds of First Amendment theories really should be thought of as fundamentally listener-based in a certain sense, in the sense that the target or the goal of that truth-seeking is with respect to the listener who hears this idea and who thereby can change his or her mind or update his information, right? Develop new ideas. That's the piece of things that we ultimately mean to protect. And so, in having said this, the framework that I'm suggesting here doesn't somehow undermine lots of stuff about the ways in which corporate and commercial speech have actually been treated. Actually, a lot of things are perfectly consistent with what I just described, right? Like it or not, the theory I just described is perfectly consistent with the theory in Citizens United, for example, right? So the idea there in the terms that I'm just describing is that the reason why the corporations have a claim in that case is because the voters need access to that information. And it's quite troubling, potentially, for the government to be able to say what kinds of access voters should have to what kinds of information, right? And so if you adopt even the sort of listener-centric theory that I've just described, you can easily defend still Citizens United. You can defend a lot of the cases about commercial advertising and the like. It's also in some sense consistent with what Jane described this morning about concern over false advertising regulation, because in that case, in the terms that she was describing it, it's a lot about sort of the balance between the ways in which these regulations might prohibit false or misleading messages, but might also stifle the receipt of truthful messages on the part of the consumers who are being targeted in these ways, right? And so this consumer-facing or listener-oriented perspective doesn't sort of establish that principle one way or another. But that's not to say that it doesn't matter, because this principle does matter, and so I'll identify three kinds of cases in which viewing the corporate and commercial speech doctrines in this way potentially makes a real difference. So in the interest of time, I'm going to somewhat gloss over two of them and maybe focus on the third. The two I'm going to gloss over a little bit are, one, speech that should be regarded as among commercial entities. That is to say, when effectively the listener is acting in a commercial capacity as well as the speaker, and that in that context, essentially where effectively, your initial defense of giving rights to the speaker is that it's in order to protect the listener. When the listener itself is then not an entity with intrinsic interest, then it seems as if neither party to this transaction has an intrinsic interest, and therefore it's derivative of nothing, right? There's no underlying interest as to which the claim can be derived from. And I think this is an important area, particularly with respect to privacy and privacy regulation, because it helps to distinguish certain kinds of restrictions on information flow from others. Distinguishing in particular, I would say, between, for example, restrictions on data brokerage among a lot of the parties involved in sort of the consumer transactions on the internet. From, for example, some of the things that Renee talked about with respect to access that individuals might have to get legal information, right? In that context, we're talking about individuals who are in fact trying to get a certain kind of information, and in that sense might be potentially quite distinct from some of the situations in Sorrell, such that you could both think, as I largely do, that Sorrell was wrongly decided, and yet still think that there's First Amendment values that underlie some of the claims that Renee was describing as well. So that's one. The second is in the context of prohibitions on unwanted marketing, in the sense that if we're going to give a commercial speaker a claim only insofar as it's derivative of the claim of the listener, but the listener has specifically said that he doesn't want to in fact receive this speech, then that would also undermines the First Amendment claim in those kinds of contexts. But the third, and this one I might spend just a little bit more time on, is in the context of compelled disclosures. Because in the context of disclosures, the courts increasingly these days have talked about compelled disclosures of all sorts, as if they were essentially theoretically identical to the classical compelled disclosure cases, namely Barnett and Woolley, cases that involve things like forcing a school child to pledge allegiance to the flag, right? And so the move that we get is the move that suggests that anytime we compel anything, it looks just like compelling the kid to pledge allegiance to the flag, unless you can sort of carve out an exception of one sort or another. And there have been these supposed, quote, exceptions carved out over the years, the primary one being the Zauderer standard, which applies to certain kinds of compulsions of commercial speech, supposedly, but supposedly limited potentially either by the need to cure deception or by it applying only to factual and uncontroversial information. The Zauderer case itself involved attorney advertising, so actually back to the sort of the attorney cases, in which a contingency fee lawyer advertised that if you lost your case, you wouldn't pay anything without disclosing the fact that you might still have to pay court costs, expert costs, and other kinds of costs of that sort. You just wouldn't pay any attorney's fees as a result, if you lost your case. So the court said that disclosure could be required there under a looser standard than that would normally be applied. And thus far, we've got a series of circuit court cases basically trying to figure out how far does the Zauderer exception extend. So my claim is that's exactly the backward way of actually looking at the issue, right? So that suggests that, initially we're just going to say that everyone's got this, right not to be compelled to speak, and then we're going to craft this exception potentially quite narrow. But that right not to be compelled to speak only makes sense if the speaker itself actually has an intrinsic speech interest, actually has an interest to be protected against being compelled. And that makes sense with respect to the school child being forced to pledge allegiance to the flag, but doesn't make sense with respect to either corporations or people in the conduct of the businesses that they're conducting. And that would suggest that many forms of compelled disclosure of a commercial variety ought to be perfectly okay. For example, Vermont recently is trying to, did in fact, compel companies to label the use of GMOs in their foods. Now my at least slight link to technology here. That, it seems to me, is a pure compulsion in a commercial sense, in the sense that the compulsion attaches to the act of actually selling these foods in the first place, and therefore should be thought of as a compulsion triggered simply by the act of doing business rather than a compulsion of some different sort. Now, on the other hand, I think the trickier cases come when the compulsion is triggered on the basis of advertising itself. And I think that is actually the reason why the Zauderer case itself actually involved some scrutiny at all. It involved scrutiny because the compulsion was triggered by the advertising the attorney was doing, and so then we potentially need to be careful about imposing a disclosure requirement that then chills some other form of speech that we then mean to protect, okay? But even then, of course, the reason presumably that we want to protect that kind of speech in that kind of commercial case is, again, still because it will redound to the benefit of the listeners, of the consumers who receive it. But again, so in those kinds of contexts, then we might then need some form of scrutiny, probably though not strict scrutiny of any sort here, but at least some form of scrutiny in order to be able to think about what effect the disclosure requirement might ultimately have on the access to the individuals have to information. Okay? Again, see Jane for respect to, I think, what some of her perspectives might suggest with respect to the framework that I've just described. So I'll leave it at that. There are various caveats and extensions in various directions that I can talk about, but I'll leave it with that, and thank you for having me.